Thank you, Your Honor, and thank you, Dr. Bell.
Thank you.
Thank you. Recollect.
What do I do? Good afternoon again, Dr. Val.
Thank
Let's
you.
make sure we cover a few things. You did a report, and I think it was 6 pages, correct?
7 page. I mean,
7 pages, I'm sorry.
my notes.
Right, you did a report, but then you also made notes too.
Yeah, 7 page
Okay, all
notes.
right. You made 7 pages of notes, and your report detailed your diagnosis and findings, did it not? Your
Okay.
medical examiner report
Oh
detailed
yeah, the
what you
autopsy
did.
report. Yeah, that's
Yeah,
autopsy.
the autopsy report.
Okay. Yeah. Let me see.
Okay.
Total 6 pages autopsy
Okay.
report.
All right. And you documented your findings in this case?
Yes.
In terms of the gunshot wound, detailing, describing the,
Yeah, I typed the report on same day
okay.
because you cannot rely on your memory
Right.
to testify, say truth, not about truth, because you don't know the truth. Okay.
So at that time, it was very fresh in your mind, and you did it that same day?
Yes.
Okay. And you documented your findings on the report?
Yes.
Okay. And then you created some notes to help you testify in court, so hopefully it would be easier?
Yes.
Okay. Like, make sure you had your name down right in terms of all your education, so it'd be easier for you to tell the jury?
Yeah. Even before the deposition, I told you I spent a whole weekend from 8 a.m. to 8 p.m.
Okay.
I come to my office, I lay down everything.
Yes, sir.
I try to figure out what I can remember.
Right.
I could not remember anything.
Okay. And in fact, in the deposition, you provided both sides, defense and state, with some answers to some very simple questions about what a homicide is.
Yes.
The definition of intermediate range pattern, correct?
Yes.
And in it, you put in terms of 0.4 inches to 4 feet.
Yes, based on the literature I used.
Yes, sir. And you also provided to both counsel the, and I'm going to mispronounce it, the intermediate?
Intermediate.
Okay. Tell me again, now that is where you have clothing, right?
Oh yeah, it's called intermediary.
Okay.
Intermediary means you have something between the muzzle of the gun and the target, means skin of Trayvon Martin.
And as you stated in the notes you provided counsel to the state and defense and deposition, you believe in this case there was something, the 2 sweatshirts,
Yes.
correct? Okay. Now, you also, a lot of photographs were taken. We've only shown some of the photographs, but you
Yes.
took other photographs.
Yes.
Not you yourself, but other people did that were working for you, correct?
Yes.
Okay. And in those photographs, Your Honor, may I have some assistance with the lights? I apologize. I want to go back to 2 of the photographs, number 89 and 88. When the body came in, when Trayvon Martin's body came in, did you yourself have to look at the hands yourself?
Yes, I look at
Why?
every
Why did you
case.
have to look at the hands?
Because, yeah, look at the picture now. I understand why we did not do the photo of palm, because when people die, the hand like this, the contraction of the muscle. So my job, the first thing, I want to bend them out, and after I release my hand, the hand will back again like this. So it's very difficult to take a picture without my hand to bend them, then ask another guy to take a picture. I think that's why we did not take picture for this case.
Yes, sir.
We do not do picture for palm for any other case.
And if there
It's
had been some
difficult.
blood there, would you have taken pictures to document that there was some evidence there that was important?
Yes,
Okay, and there wasn't any blood or injury to the palms
No.
of his hands?
I look at myself. Every case, I believe in this case, I did same thing.
Okay, all right. So in other words, you're saying when you die, your body, I guess, your stuff to your body kind of curls up?
Yeah, this is
Okay.
this is standard. Everybody do that after they die.
Okay. And you also mentioned the injury, State's Exhibit number 97. Since you did find something there, you did document that by that photograph, correct?
Yes, yes.
Okay. Thank you, Your Honor. I think that's it for the lights. I'm going to ask him some more questions. Thank you. You were asked about the scrapings of the fingernails. That was done by one of your technicians that works for you, I believe, Mr.
Yes.
Ben
Ben Dalton. Yes.
Okay. And he's trained to do that, or did you just that day tell somebody to come off the street and say, hey, come in here, or has he been trained to do that?
Yeah, he was trying to do his job. He had previous experience with some other job, and after he came in, we have senior technician train him to do the job, and after 3 months, we decide he knows everything.
Okay, stop 1 second.
Vouching for a witness that's not here and subject to cross-examination.
Okay. Can you move on?
I'll be moving on, Your Honor. You mentioned, may I approach the witness, Your Honor?
Yes, you may.
You did recover some blood was recovered, correct? For
Yes.
DNA purposes, correct?
Yes.
The bottom line, Dr. Blau, whether it's from 1 to 3 minutes, from 1 to 10 minutes, he was going to die
Yes.
and never recover from this gunshot wound, correct?
He had no chance. There are 2 defects on the heart.
So the bottom line, it could be as little as 1 minute, up to 3 minutes, or up to 10 minutes,
Yes.
correct?
Yes.
And in your deposition, you stated from 1 to 3 minutes, but you recently came across a case where somebody could have lived to 10 minutes, correct?
Yes.
And by the way, in terms of, you didn't go to the scene, correct?
No, I did not go to the
I
scene.
object to the leading nature of the last several questions.
Okay, and this question, if it's just to get to a point in testimony, I will allow it.
You were asked by Mr. West to, I think at some point, review your investigator's report that went to the scene. You recall that?
Yeah.
Tara Malferris or Tara
Yeah,
Clark, I think
yeah.
is
I
her
did not
name.
go to the scene. I just rely on her report here. I do not want to testify on her behalf because I don't have fact.
You didn't go to the scene yourself?
Yeah,
Okay.
so I don't have opinion.
Okay. If the evidence, hypothetically, if the evidence showed photographs there at the scene by the police department, that the body was covered in a tarp, a
Yeah.
tarp was covered over the body, would that in some way protect the body?
Yes, before I came here, I did review the scene photos. Not
Okay.
because I want to scene, but because I reviewed photos.
You reviewed
Few
photos
days.
that were taken by the investigator?
Yes, I reviewed it a few
And-
days ago, even yesterday.
Right. And was there indication that the body had been covered at the scene?
Yeah, according to my memory, the new memory, not the memory 1 year ago, that the body was covered by orange something.
Okay. And when you say, in terms of Trayvon Martin, in terms of the 1 minute minimum, up to 3 minutes and all that, in other words, his brain was still functioning, but he wasn't able, was he able to get up and do jumping jacks and all this stuff, or not?
I believe brain is the minimal functioning. I don't think he can move based on my case, our case, 3 weeks ago.
Okay. All right, don't refer to the other case, but just based on your experience, you don't think he can move around and do all
Because
kinds
I don't know Trayvon Martin's case. I have to refer previous case to predict
Sure.
Trayvon's case.
Okay, all right. And in other words, well, strike that. Tell me how to move, Your Honor.
Yes, May?
I don't have any further questions, Your Honor.
Thank you.
Thank you.
Thank you. May Dr. Bao be excused?
Subject to recall, depending on...
Okay, thank you. You're excused from the courtroom, subject to being recalled. Thank you very much.
Thank you so much.
Okay, call your next witness,
We
please.
have a break.
Okay, we may.
Apologize. I was presumptuous on...
Yes, we'll take a 10-minute recess. Court is in recess for 10 minutes.
Now as well as I do, it's off of South French Avenue, 1792, and historic Goldsboro Boulevard, which is just several miles away from the Treaty Circle. It's much closer to downtown Sanford, Goldsboro, and of course...
That doesn't give you a distance on there?
Oh, it doesn't, no, we would be, not yet.
Sanford Police Department.
You know where Sanford Police Department is? It's very close to that. So that's the location. And of course, you know where Retreat Circle is, which is very close to the mall. So it's that difference. I would say it's several, 4, 5 or 6 miles.
In our position, it's the closest thing we have, so it's the best information we can give the jury about the actual wind speed and rainfall amounts during the relevant time period.
Okay, any further argument about the request for judicial notice regarding weather conditions?
Just for distance and the existing testimony.
Okay, be overruled. We'll have this marked as State's Exhibit 213, I believe it is. Is that correct, Grace? Okay. Is there anything else?
No, Your Honor.
Is the state going to rest?
Yes, Your Honor.
All right, let's have any arguments that we're going to have now, and then you'll rest when the jury comes back in.
Rich.
On my approach, as just another acquittal argument with case law just presented in the state and the court, and I see I'm getting some as well.
Thank you. Yes, you may.
There are a number of different issues that come to mind that needs the court's attention, and I can focus the court on some of the case law that addresses it. One is the extent to which that there is a standard for judgment of acquittal in a circumstantial evidence case. Of course, it's up to the court to a certain extent to determine whether or not there is any direct evidence of my client's guilt and direct evidence which would counter-indicate my client's self-defense that has now been properly presented, actually by his own statements, but has now presented to the jury and to this court by all of his oral and written statements that have been provided. So, firstly, the court has to make a determination whether or not there is any direct evidence that would support ill will, hatred, and spite, which is really the operative element of second-degree murder, which the state would need to prove exist in order for this matter to go forward to the jury. So as to the circumstantial evidence nature, of course, to the extent that the state intends to use circumstantial evidence to prove up their case, even, of course, at this stage of the proceedings, which is while you still have to look at the evidence that does exist in the light most favorable to the state, nonetheless, you have to look at that direct evidence in the light most favorable to the state and circumstantial evidence in the light most favorable to the state, but the same standards still apply, and that is to the extent that the state intends to use circumstantial evidence, that even in the light most favorable to the state, that circumstantial evidence still has to negate any possibility of innocence of my client. So even when we look at it under the judgment of acquittal, and I'll tell you the cases to look at in a moment, you have them in front of you. So if you were to focus on Walker versus State, cited at 957 Southern 2nd 560, a Florida Supreme Court case from 2007, that case does talk about the judgment of acquittal and says that in the case where no view which the jury may lawfully take of it favorable to the opposite party can be sustained under the law, and says in circumstantial evidence cases the judgment of acquittal is appropriate if the state fails to present evidence from which the jury can exclude every reasonable hypothesis except that of guilt. So the standard still is, to the extent that we can look at direct evidence and the court may consider the expletives that have been used as some, well, I would argue with it, but I guess the court could look at it and say the words that he used might evidence, maybe direct evidence of ill will and hatred. I would suggest that though maybe the way other people have said it or screamed it in the courtroom, the evidence that's before the court and before the jury, the way my client used it, and certainly the entire context of the way he used it in his conversation on the non-emergency call does not suggest anywhere near the level necessary for ill will, spite, and hatred. Under that suggested, if you were to even consider that direct evidence, short of that, I would suggest that there is no other direct evidence to support any contention whatsoever of second-degree murder as to the ill will, spite, and hatred argument. The circumstantial evidence, then, that may exist, and they've tried to present to you that my client is some, I'm not exactly sure what the state's case is yet, but to the extent that what they're trying to say to you is that my client was a frustrated neighborhood watch and cop wannabe and just sort of had enough, and that is supported by some circumstantial evidence. I don't think that they have any direct evidence to suggest that. In effect, what they have shown is that my client has in fact been frustrated because he's called before, and on occasion the people he's called on have gotten away. However, rather than just having the huge bridge that needs to happen from that suggestion to ill will and hatred, that circumstantial evidence has to negate any hypothesis of innocence of my client, even in a judgment of acquittal standard. That being, you look at that evidence in the light most favorable to the state. It still, pursuant to Walker, has to exclude any reasonable hypothesis of innocence. And I would suggest to you that now what you have before you, what the jury has before it, is not only some reasonable hypothesis of innocence, but a very well-founded reasonable hypothesis of innocence, and that is that my client acted in self-defense. Because though you do look at all the evidence in the light most favorable to the state, you have to look at all the evidence. You can't, I don't mean to suggest this as though you don't know the standard, but you have to look at all the evidence. You can't just call out parts of evidence and say, if I take these 4 pieces of evidence and look at these in the light most favorable to the state, then I can see where judgment of acquittal should not be granted. You have to look at the entirety of the evidence that's before the court and therefore the jury. And what is before the court is an enormous amount of information that my client acted in necessary self-defense. We will not know yet, and you don't know yet, who was screaming. And if you were to look at any evidence in the light most favorable to the state, you have equivocal statements of the only 2 people who have talked about it. You have Javarius Fulton, who says, I really want it to be him and not sure. And then, of course, quite honestly, you have Miss Fulton, who, though she did testify, that is her son's voice, you have to take it in context. You have to understand reasonably why she would say that, how she would say that, and quite honestly also the circumstances under which it was done. That piece of evidence in and of itself, a mom saying that has to be my son who passed away, that has to be his voice because any other possibility means my son caused his own death, you could consider as evidence. However, you have to take it in context. You have to take it in the reality of the other undeniable circumstances that existed that night. And here's what existed that night in the evidence that you have to consider. My client's immediate statement to those who listened to him that he was screaming for help before he knew that that was being recorded. We can have an argument that he's this new cop wannabe who would know that it's going to be recorded, but the reality is the first person on the scene he told it to, the second person on the scene he told it to, the officer, that's Manalo and the officer, and he has the undeniable injuries that evidence nothing other than a violent attack by Trayvon Martin. There is no other reasonable hypothesis that could come from that undisputed evidence other than my client was attacked by Trayvon Martin. Some form or fashion. Is it determined quite yet how, in what precise moment? Maybe not. I would suggest that there is absolutely no evidence to contraindicate what my client now has before you and before the jury, which is that he was at the T intersection when he was attacked, approached, and then attacked by Trayvon Martin. So there's no evidence to contraindicate that. And that he was hit in the face, and there's no evidence to contraindicate that. And that it did what we all know now it did to his nose. That violent act, in and of itself, I would suggest to you, is sufficient for immediate response with deadly force. But he didn't. What we have is 40 seconds of somebody screaming. Of course, you know, my client, through his statement, said it was him screaming. 40 seconds, and receiving additional injuries consistent with, and even the state's own experts said it was consistent with my client's head being bashed against concrete, or hit, contacted, without using the emotional word of smashed, against concrete at least several times. That type of injury, in and of itself, the way it was presented by my client, that injury and the ongoing nature of that injury supports the right my client under 776 to reasonably believe that he is in fear of future bodily injury because it was ongoing. The state's own witness, Captain Carter, said one really good indication of future bodily injury is when you've already been injured and it's still ongoing. You can presume that it's going to continue to occur. And that is, in effect, why my client acted in self-defense. And there is nothing, most importantly, under Walker, there is absolutely no interpretation of the state's evidence which excludes that as a reasonable hypothesis of innocence. And if you read Walker, the very words that I said, but the whole case is quite instructive. It allows for no other determination that since my client now has presented self-defense through the state's case, but it is now affirmative evidence of why he acted and the way he acted, that since the state cannot exclude a reasonable hypothesis of innocence based upon their circumstantial evidence, that the judgment of acquittal should be granted. That's under Walker. Walker also cites Woods, and it is the Woods case, which also cites another Supreme Court case, which is Barwick, B-A-R-W-I-C-K. Barwick case is 660 Southern 2nd, 685. In 1995, Florida Supreme Court case that also sort of began the premise in Florida law that the judgment of acquittal is appropriate if, in fact, the state fails to present evidence from which the jury can exclude every reasonable hypothesis except that of guilt. You, as Barwick says, Barwick again is 660 Southern 2nd, 694. Barwick tells us that you at the outset have to determine whether or not there is competent evidence from which the jury can infer guilt to the exclusion of all other inferences. I would suggest to you that this would be a textbook case. It wouldn't make it to a textbook because it is so apparent from the evidence presented at this stage of the proceedings, judgment of acquittal after the close of the state's evidence, that the inference of non-guilt is much stronger than any suggested inference of guilt. Barwick, Woods, and Walker stand without question and unassailed for this proposition and should be considered by the court as to the circumstantial evidence issue. There are other cases that I would cite for you, and you have them in front of you. Sims is a 2013 case, 110 Southern 3rd, 113, talking about the state's obligation to eliminate any reasonable hypothesis of innocence, and upheld that the judgment of acquittal in Sims should have been granted, and in fact, again, was upheld. And in that case, it also cited to law, State versus Law, LAW 559, Southern 2nd, 187. And again, all of the cases that I'm citing to you, Your Honor, you have before you, although there are some of the cases, and I believe law is one of them, since it was cited in Sims fairly well. You don't have that actual case in front of you, but the cite is quite specific. The S-T-I-E-H versus State, 67 Southern 3rd, 275, was an interesting case for the court to consider. That's a second DCA case that's been out for a couple of years where there was a stabbing and the defendant argued self-defense and an ag battery, and the second DCA advised the trial court that it should have granted the motion for judgment of acquittal once the defense had provided or presented a prima facie case of self-defense. Now, I don't know if you believe that he has or not, so I have to argue both sides of it. I believe that the court should consider, and in fact should decide, that my client, through his statements over the last week and a half as they were presented, not only his statements, but all the supportive or corroborative evidence, and those are all of the witnesses, that my client has in fact presented a prima facie case of self-defense. And I mentioned it a moment ago, but just to make sure that the foundation is properly laid, we have my client's, if we set aside for a moment, I'm going to ask you to, set aside for a moment that my client is just the most amazingly competent protector of his own murder, that, set that aside for a minute, that he didn't just decide as some snap decision to become a murderer and then was perfect in covering up everything. Because I would suggest to you that that is a fallacy of absurd proportions, that such could even be suggested by the state, certainly considered or actually endorsed by you. But if we set that aside for a moment, then what we have to look at is my client, it gets in the altercation with Mr. Martin. After following him to see where he went, as he agreed to with the officer, by not following him after he was told not to by dispatch, and to date, and the state's case is now done, to date, They have not presented any direct evidence, and I would suggest not even circumstantial evidence, that my client followed him after being told not to by the dispatch. They have no direct evidence, no circumstantial evidence that my client ever moved from the T intersection down the dog path until he was drugged or forced there by Trayvon Martin. There's not a scintilla of evidence to support that. There was, it seems, by Miss Bahadur, at some point, though I would suggest it was highly incredible, that she suggested that for the first time she came up with the idea that maybe somebody is moving left to right. I'm sure you recall that. May well have been Trayvon Martin coming back for the attack. We don't know, but to suggest that that somehow inculpates my client to being the one moving is a stretch that I would ask that you could not consider making. It's certainly not one that's supported by any other corroborative facts or evidence. And of course, I think Ms. Bahadur sort of came across, well, let's just say she came across as she came across by the time we were done with her testimony. But aside from that, there was nothing to support that my client did anything to re-engage or to engage Mr. Martin whatsoever. So if we're going to set that foundation, that that is what he did and didn't do, and then see what the foundational evidence is to support that, we have Jenna Lauer. Jeremy Weinberg didn't testify. He was the woman, so he was the fiancé with Jenna Lauer, but Jenna Lauer testified to something that, again, without my client's knowledge, completely supported what he said and how he said happened at the T intersection. Even Ms. Sudaika, who thought she saw something, and I think thought she heard something a lot different than she saw or heard, through an open window or a closed window, whatever, still supports my client's contention that the altercation began down by the T intersection. Of course, the Manalos also do that as well. So without having the benefit of any of that testimony, we know that my client, of course, gave all that information to both Officer Singleton and Serino at a time when he had no information that any of that was available. Much more importantly, he had no information that any of that was controverted. Because had any of that been controverted, I'm sure that the state will well have brought that out to you before the end of their case. So we have Lauer, we have Sudaika, we have Manalo. We actually even have Mora, who documents my client's hypothesis of innocence or his prima facie case of self-defense. And that is, as she says, when she sort of wandered around the courtroom to look over the column to say that she saw my client on top of Trayvon Martin. A statement that he had already given to Singleton and Serino before he knew that this witness would be able to come out and say he or she saw anything. But he stated exactly what he did, that he moved the hands out. I think giving Dr. Bauer's testimony would certainly support the idea that even having moved the hands out, as Ms. Moore said, the feet still move. Dr. Bauer seemed to say at some point that maybe the body can move, maybe it can't, but nonetheless, this is the foundational evidence for which you have to make a determination. Did my client present to date a prima facie case of self-defense? One, and two, is that prima facie case of self-defense and its reasonable hypothesis of innocence, which is, of course, what it is, specifically contradicted by the state's case. And under Walker, Woods, Barwick, and now, as I've mentioned to you, STIEH, S-T-I-E-H, they have failed to do that. So if we look at STIEH, which is interesting, out of the second DCA, and I don't know that I quoted it, apologize if I have already, 67 Southern 3rd 275, stating that the JOA should have been granted once the defendant had presented a prima facie case of self-defense. And it goes through a pretty good analysis of 776. In that case, they were talking about defense of others, but of course the same standard applies as we have here today. Jenkins, I think, is one of the most instructive cases. That's cited at 942 Southern 2nd 910. The reason why is because Jenkins, a 2006 case, remember, as an aside, that there are not a lot of cases about judgments of acquittal in self-defense cases after 2006. The reason why is, of course, we now have self-defense immunity hearings as an alternative to judgment of acquittal arguments in a trial. We did not avail ourselves of that pretrial determination of immunity. So many other people in most of the other case law have. So you'll see a significant drop-off in the number of JOA arguments or JOA appellate case law after 2006 on a self-defense issue because, as you would imagine, most of them exist pre-trial, they're addressed pre-trial. We had made the voluntary decision not to do that. But Jenkins, what Jenkins is good for, Your Honor, is that, first of all, the facts are close. Jenkins was in his house. A guy was outside making a lot of noise. He went outside. Jenkins did try to minimize the altercation. Cesaro, who was the eventual victim in the case, made a maneuver towards him, punched him in the face, wobbled back, goes Jenkins. Then the assailant comes again. Jenkins takes out a knife, catches him in the heart. He passes away. Jenkins, the case, as opposed to just the facts, is very significant because Jenkins goes through and cites about 7 cases, which is the recent history of judgment of acquittal cases in self-defense cases, judgment of acquittal issues in self-defense cases, and is a pretty good rendition of it. It references, for example, Thompson, which is State versus Thompson, 552, Southern 2nd 24. That's an aggravated battery case where he tried to stop a fight, was attacked, defendant backed up, brandished a gun, aggressor continued to approach, defendant shot him. And that was where the court reversed the conviction on that, suggesting that the judgment of acquittal should have been granted. The Hernandez-Ramos case at 496 Southern 2nd 837, again cited in Jenkins, gives some good insight into a somewhat similar fact scenario. In that case, evidence was there that the defendant took some effort to ward off the attack or end it without violence. The state's witnesses in that case uniformly identified the victim as the aggressor. We have one eyewitness in this case, John Good, I think, would present a scenario very similar to that presented by the state witnesses in Hernandez-Ramos, and that is that we know, and it is completely uncontroverted, that Mr. Martin was the aggressor in that he had mounted Mr. Zimmerman, refused the suggestion by Mr. Good to stop doing what he was doing and continued the attack. Similar to Hernandez-Ramos, the state's witnesses in that case suggested that the victim in the case was the aggressor. And again, that case similarly was suggested that judgment of acquittal should have been granted. Now, that is looking at the issue of the circumstantial evidence and the direct evidence would exist and whether or not my client has presented a prima facie case of self-defense. I think that if you reach that alone, then the case should simply be dismissed presently at judgment of acquittal. As I said a moment ago, I can't say, Judge, can I stop and let you rule, and I'll start over if you don't. So I have to continue as though you're not following my first track, and I'll go to my second track. And the second track is whether or not, should the court not agree that a prima facie case of self-defense has been proven, and that to the extent that circumstantial evidence is being considered by this court as presented by the state, if you decide that that does in fact exclude any possibility of my client, any hypothesis of my client's innocence. If for some reason I've lost those two arguments, which I think the evidence supports that we should win. If we don't, then you have to look at whether or not this case should still move forward on a second-degree murder charge as to the issue of ill will and hatred. So let's talk for a moment about what ill will and hatred is and what it's not. In Light versus State, 841 Southern 2nd, 623, a second DCA case, that was a mosh pit case. Mr. Light didn't like the fact that the eventual victim fell back into him and may have hit him in a sensitive area of his body. So Mr. Light decided to pick him up in a wrestler move, hang him over his head, and smash him to the ground, crushing the left side of his head, I think it was, on the cement. He sort of got up, made it outside, and died. And the court ruled that that behavior, though extremely reckless behavior, to simply get upset at somebody, pick them up over your head, and smash them onto cement, is not ill will or hatred, and would not sustain a second-degree murder conviction, because you can't infer any malice. I don't exactly know how you can infer malice from picking somebody up over their head and smashing them onto cement, but if we were to compare that law, which is now the law in Florida, to this case, I would suggest that there is absolutely no evidence to support the contention that Mrs. Zimmerman acted in ill will, spite, or hatred. If you can get past the expletives, and you get past the fact that he seemed to be particularly interested in his community, and that may have been why he focused on Mr. Martin as a suspicious person, looking unfortunately similar to what we now know we have in evidence of Emmanuel Burgess, who was his one-person crime spree through Retreat View Circle, who got 5 years in prison for his bevy of burglaries in the area. The court may recall that you were the sentencing judge in that case when he came before you about a year and a half ago. So yeah, an unfortunate circumstance, but that doesn't allow the outrageously over response by Mr. Martin. For sticking to the ill will and hatred argument, basically in the Light case, it was just not ill will because the courts looked to two other cases for the instruction on ill will, spite, and hatred. That being Williams versus State at 764 Southern 2nd, 177, another second DCA case, and McDaniel versus State, 620 Southern 2nd, 1308, a fourth DCA case, to begin the analysis that even extremely reckless behavior itself would be insufficient for you to infer any malice that would suggest second degree. I guess in this case, had Trayvon Martin pushed my client, as happened in the Light case when he actually hit him in the genitals, had Trayvon Martin pushed my client and then my client just reeled back, took out his gun and shot him, under Light, I'm not certain that would have been ill will, malice, and hatred, because the other overriding necessity in an ill will and spite and hatred case, and I know the court is aware, is though second-degree murder for ill will, spite, and hatred, not exclusively, because they'll never say never, but almost always, the people have to know each other. Because the ill will, the spite, the hatred cannot be momentary, it cannot be instantaneous. All of the cases that talk about ill will, spite, and hatred talk about, in 99% of the cases, and that's my percentage, not the case laws, but in the overwhelming majority, it only occurs where that ill will, spite, and hatred has been something that has grown over time. The husband and the wife with the affair, the neighbors fighting over the fence, things like that, so that we can presume that there is ill will, spite, and hatred by previous acts against the two. And it cannot be presumed. It has to be by direct evidence that there was this previous animosity that would suggest the growth or therefore existence of ill will, spite, and hatred. Similarly, there are two other cases that at first I didn't think that they were worth mentioning, except as I thought more about them, they were as to the issue of ill will, spite, and hatred, and that's State versus Ellison at 561, Southern 2nd, 576, the Florida Supreme Court in 1991. And sorry, Your Honor, and that's Siegler, S-I-G-L-E-R, 805 Southern 2nd 32. I mentioned those two cases for this reason. Those were the high-speed chase cases. Factually significantly different from this case, but interesting because in both of those cases, the defendant, one had just escaped from prison, another one had stolen a car, I believe, were high-speed chases, 80, 90 miles an hour, running through intersections, running over curbs, running through toll booths, and just acting as about as outrageously as you could act while in a vehicle. And in both of those cases, the courts said that even when you run into somebody and kill them, that's not ill will, spite, and hatred. There's no, in effect, transferred intent from when you act as outrageously negligent as you might act to steal a car and do 80 or 90 miles an hour through a crowded area, running people out of the way and finally killing somebody. That's not ill will, spite, or hatred. So I mentioned those for that purpose. Another case, State versus Ellison, E-L-L-I-S-O-N, 561 Southern 2nd, 576. I'm sorry, that was one of the two that I just mentioned to you, Your Honor. I apologize for that. But that was one of the two cases where, again, in that case, the high-speed chase was not suggested to be ill will, spite, or hatred. Dorsey versus State, 74 Southern 3rd, 521, a fourth DCA case, just a couple of years ago, 2011. In that case, the defendant had a gun. It is the facts support that he actually went and got the gun to arm himself after having an argument with two victims. Then they came to the car, further attacked him. One guy punched him in the face, and after having armed himself voluntarily in anticipation of continued altercation with these guys, which is the facts of the case, he got hit in the face, took out the gun, shot him, killed both of them, and the fourth DCA said, in that circumstance, where you went and got a gun and came back, no ill will, no hatred, no second degree. An impulsive overreaction to an attack or injury is in itself insufficient to prove ill will, hatred, spite, or evil intent. They were at a keg party and people were getting drunk and they were hassling him. Okay. Bellamy is another case that I presented to the court, 977 Southern 2nd, 682, DCA, second DCA case out of 2008. This was a fight that lasted a couple of minutes, basically a bar fight where they went back and forth, and to the extent of the client, in that case Bellamy's, responsibility in that regard, even though there was no evidence that the victim of the final stabbing by Mr. Bellamy wasn't even known to have caused his own death, so he was in effect what was thought by the court to be an innocent bystander, and that Bellamy may have just reached out and decided to start stabbing people, including this guy. There was no ill will or hatred found in that case either. And again, they mention in that case particularly, and also cite a number of cases standing for the proposition that you really, ill will and hatred almost always and only comes from people who know each other before the event begins, because it is almost impossible for that ill will and hatred to grow so quickly in the middle of an affray or a fight or an altercation, quite honestly, such as we have here. Wiley versus State, 60 Southern 3rd, 588. Interesting case because in that case, there was a fight and Wiley decided to take out his gun and smack it against the eventual victim. So it was a deadly weapon, but he didn't use it as a gun, but he used it as a hammer. As it hit him, it went off and killed him. And again, in that case, even though he decided to arm himself with a deadly weapon, decided to do it the way he did, since the intent was not there and there was no ill will and hatred. Presumably it would have been found if he stood 5 feet away and shot him. They said that the action and the way it occurred suggests a lack of ill will, hatred sufficient for second-degree murder. So it's a complicated case on judgment of acquittal, I think, in a number of ways, and that is that in a self-defense case, the case law, Walker and others, Woods and others, are quite clear that even at judgment of acquittal stage, the state has to be able to, in effect, disprove a reasonable hypothesis of self-defense. Even in the light most favorable to the state, all of those standards that the state has to present, all the factual scenarios have to convince this court that a judgment of acquittal should not be granted because they have presented evidence which negates every hypothesis of self-defense or hypothesis of innocence, which they're synonymous for these purposes, that my client acted in self-defense. Failing to do that, Walker is the law of this land and suggests that a judgment of acquittal should be granted. If it is not granted outright because they have simply failed to disprove self-defense, of course you know that to be the standard for the jury to consider anyway, then we shouldn't even need to present a defense. And if for some reason, as I mentioned a moment ago, you think that all of that is just has to be ruled in favor of the state, not giving my interpretation to Walker and its progeny any consideration whatsoever, then certainly the state has failed in convincing that second-degree murder charge, evidencing a depraved mind, has any basis moving forward to this jury because they simply have not presented any evidence to suggest that there is not a reasonable hypothesis that my client did not act with ill will or hatred, and that they need to present, though they get the benefit of all the evidence being presented in their favor, that what they don't get is the benefit of you ignoring evidence that can't be interpreted any other way. You cannot look at that picture of my client's nose and say that he wasn't beat in the face. You can't look at the back of his head and say he wasn't beat in the back of the head. You cannot look at the autopsy of Mr. Martin and realize my client never attempted to nor landed one blow upon Mr. Martin. All my client did was scream out for help. Mr. Good, though he was questioned a lot about this area, did finally, I think, opine, though he didn't see gas escaping from my client's mouth as he was the one screaming towards him, that he said that it was his thought and his common sense that it was, in fact, my client screaming out for help. And the reality is, had it been Mr. Martin, who we now know, and it's undisputed, was on top screaming for help, well, he had his chance. He had Mr. Good 17 feet away, asking him to stop, telling Mr. Martin he was going to call 911, and Mr. Martin continued to ignore him and continued to batter my client in whatever form or fashion, or however number of times he did, that ended up with the injuries that my client had. They can't ignore that evidence to a jury, and they really should not be able to ignore it to you on a judgment of acquittal argument.
On behalf of the state, Mr. Bedtime.
Thank you. Respectfully, Mr. O'Mara gets the arguments backwards for starters. Because justifiable use of deadly force is a defense for which the defendant actually bears the initial burden, and I'm not arguing necessarily that he didn't meet it, but because it is a defense, the first inquiry that has to be undertaken is the elements of the crime itself of second-degree murder. Only then do we move to the issue of whether or not there is sufficient evidence to dispute the defense of justifiable use of deadly force. So the first thing that should be addressed is the elements of the actual crime that the state bears the burden of proving. The intent and state of mind. Included in the court's materials, and I think it's probably either the last or second to the last case in the packet, is a case of Gibbs versus State. It's 904 Southern 2nd 432. It's a 2005 opinion from the 4th District Court of Appeal. Beginning at the bottom of the first column of page 2 and continuing through the midpoint of the second column, the courts have held for a long time that when we're talking about evidence of ill will, spite, or evil intent, pointing a loaded gun at the victim and firing it is an act imminently dangerous to another and evincing a depraved mind regardless of human life. Pointing a loaded weapon at their direction, at their head, at their heart, and pulling the trigger is in fact, by itself, evidence that you have ill will toward your target. There's really no question of that. Shooting someone in the heart is by itself, on its face, evidence of ill will. Now, the defendant raises a defense saying, I was justified in doing so. But he's certainly not saying that at the time he pulls that gun, points it at Trayvon Martin's heart, and squeezes the trigger and puts a hollow point through him, that he had some kind of benevolent intention. There's only one reason you squeeze the trigger at someone's heart, and that's because you mean to kill him. Or you don't care. So the first issue is there evidence in this case of intent and spite and evil will? I submit Gibbs makes it very clear that even just given the gunshot, there's evidence of that. But let's talk that there's plenty more. We'll talk about, and I'll briefly reference the Walker case, which I'll point out is absolutely not a self-defense case. It's a whodunit case. And so when Mr. O'Mara says it's the law of the land in the analysis of the case like this, I disagree. It's not. Because it's not a self-defense case, it has zero application to at least half of this argument. But for starters, the court said this is not a purely circumstantial evidence case. Neither is this one. Evidence of this defendant's ill will towards Trayvon Martin in particular, Mr. O'Mara cast it as it's usually people who know each other. Well, the problem is this defendant thought he knew. He thought he knew. He thought he knew Trayvon Martin as one of these assholes who get away. He thought he knew Trayvon Martin as a fucking punk. He didn't know Trayvon Martin, but he thought he did. Because this defendant had enough in his heart to stop his trip to the grocery store, if that's in fact where he was going, to follow Trayvon Martin as he walked through the neighborhood in his car, to get out of his car in the rain, follow him, and then, as the witnesses make clear, pursue him and make contact with him and grab him. He had enough in his heart to do all that. So we'll talk about first the direct evidence. The direct evidence, and even the Walker case supports this, the defendant's confession, a defendant's statement, is direct evidence of his state of mind. This defendant's statements go a long way towards telling us what that was. I've already mentioned his conversation to Mr. Nofke in the non-emergency call. But we go further than that. What other things has he said about this? And I'll ask the clerk in advance if I could have State's Exhibit 210, please. He talks about the first description is he thinks he's on drugs and he's suspicious because he's walking in the neighborhood. He also says that he would do nothing differently, and this is all part of God's plan. And I don't even need Exhibit 210. I'll tell the court what it says. The first line of the first homework assignment he wrote for Professor Carter indicates that the reason he wants to be a law enforcement officer In that case, I think it was the U.S. Marshals, because he wants to hunt fugitives and make sure they don't get away. Those are direct statements of this defendant. That's not circumstantial evidence. The defense can argue as to how they ought to be interpreted, but they are in fact direct evidence. You move from that to the statements by Rachel Gentile and Ms. Bahadur, Ms. Mora, and Ms. Serdaika that all indicate that there was some pursuit that took place, and one does not follow somebody wishing them well. One does not grab them or confront them or ask them what they're doing here because you like them, but because you have some kind of ill will, some kind of spite, some kind of bad feeling towards them. The central question, as it relates to that, and I'll further point out that at least Ms. Gentile said she heard the victim in this case tell the defendant to get off. The only hypothesis of innocence as it relates to all this is in fact justifiable use of self-defense. They're not even pretending that this defendant did not kill Trayvon Martin. So the only hypothesis of innocence they offer is that. So I've covered what I believe is the direct evidence of this defendant's guilt as to his state of mind. I will now talk about the circumstantial evidence. There's the idea that he thought enough of his neighborhood watch program to trumpet it, to walk around and be proud about it, and that's fine, well and good, but the one time he actually comes in contact with someone, he doesn't bother to say, I'm with the neighborhood watch. Every time he's on the phone with the police, it's, I'm with the neighborhood watch, I'm with the neighborhood watch. The one time he's not, he doesn't bother. He follows even after, and is contrary to the training for the neighborhood watch. There was a argument, I guess, or there will be an argument about whether he was told not to follow and what his perception of that was. The defendant wrote in his written statement that the dispatcher told him not to follow. His understanding was exactly that. We'll talk about some of his claims in brief, but he lies about kind of his whereabouts. Mr. O'Mara said that there's nothing to contradict the idea that he went right from the tee back to his car. There's 2 minutes of blank time in those phone records where this defendant is apparently wandering about the neighborhood. There's 2 minutes he can't account for. If he's to be believed that he is hit when he says he's hit, the phone records prove that he had plenty of time to cover whatever distance it was, and he says he never got more than 100 feet from his truck. Number two, he keeps changing the meeting location for the police. I mean, that is circumstantial evidence that he's got something else in mind. He wants the police to meet him at the clubhouse. No, okay, go back from the clubhouse, just meet me at my truck instead. Okay, never mind altogether. Just call me when you get here. I'm not going to meet you. You find me. That's not evidence that he is interested in getting to the police right away, nor is getting out of his car in the first place evidence that he is interested in meeting the police there. What it is evidence, circumstantial at least, that he was going to ensure, because the police have always been too slow to catch these guys who always get away. They've always been too slow, and he's going to make sure that this time something stops them from getting away. The one other time that somebody got caught had nothing to do with him. It had to do with the stucco guy who followed and identified and thereby caught the burglar. And the defendant knew it. The inconsistencies in the defendant's own statements are hardly minor. I think viewed in favor of the state, which the court is required to do, and construed in the light most favorable to the state, they're evidence of somebody who can't figure out which lie he's already told, so he tells a new one. He jumped out of the bushes. No, he didn't jump out of the bushes. He was right there where you are standing in the video walkthrough. No, he's not right there where you are standing. He actually, after I hung up the phone and turned around to walk back to my truck, he was walking toward me. He says all three of those things. They can't all possibly be true. I'll submit probably none of them are true, but the bottom line is he keeps contradicting himself, and not just in some minor fashion. He claims that he knows all of his neighbors, but I don't know yet of a neighbor who testified that they actually knew who he was before the shooting. And despite the fact that he's been the neighborhood watch chairperson, that he's lived there for years, that he claims to know all his neighbors and goes about parking enforcement, he doesn't know the name of the 3 streets in his neighborhood. He doesn't know that as he's doing his video walkthrough, over his shoulder is the address that he claims he couldn't see. Those are not minor things. Those are evidence of someone who is intentionally obfuscating. And let me put it this way. There are 2 people involved here. One of them's dead and one of them's a liar. That is a circumstance that this court ought to consider, and it's a reason that the jury ought to consider. So between the direct evidence and the circumstantial evidence of his ill will, Your Honor, I will now go towards what the cases have to say about that. The only hypothesis of innocence, as I've said, is that the defendant was engaging in self-defense. Included in the packets that I've given, Your Honor, the second case I believe in order is Melihan, M-E-L-E-H-A-N, which is the 4th District Court of Appeal decision from June 6th of last year. And essentially and I believe it's on page 11 of the court's copy, the court sets out the law as it relates to this sort of motion. Moving for a judgment of acquittal, the defendant admits the facts in evidence and every conclusion favorable to the adverse party that may be fairly and reasonably inferred from the evidence. Even if this were a circumstantial evidence case, which, again, the state argues it's not. There are circumstances, but it is not a purely circumstantial case, and therefore the special burden, as it were, doesn't apply. But even in a circumstantial evidence case, the state must present evidence that conflicts with the defendant's hypothesis of innocence, but the state is not required to completely disprove it. Further, I've provided the court with the case of Sherrod, S-H-E-A-R-O-D versus State, which is the 2nd District Court of Appeal opinion 992 Southern 2nd 900. It's from 2008, and I believe I saw this in the packet Mr. O'Mara handed me too. But on page 6, I'm sorry, I think it's page 6 of the court's copy, page 5 of the opinion. Again, the court reiterates this. Unless there is no view of the evidence which the jury might take favorable to the opposite party that can be sustained under the law, the trial court should not grant this motion. The existence of contradictory, conflicting testimony or evidence does not warrant a judgment of acquittal because the weight of the evidence and the witness's credibility are questions solely for the jury. Where there is room for a difference of opinion between reasonable men as to the proof of facts from which the ultimate fact is sought to be established, the force of such conflicting testimony should not be determined on a motion for judgment of acquittal. And finally, Your Honor, I've also provided the case of Thompson versus State, 944 Southern 2nd 546, another 4th District Court of Appeal case, this one from 2006. And beginning on page 5 of this copy, again, in the second-hand column, they talk about the generalized burden, and then they say this. When moving for judgment of acquittal based on the insufficiency of the evidence, the defendant admits not only the facts adduced in evidence, but also every conclusion favorable to the state that a jury might fairly and reasonably infer from the evidence. So, Your Honor, as to whether the state has met its burden at this stage, regarding the defendant's intent and state of mind. I submit that both through direct and circumstantial evidence that has certainly been done. In fact, the only hypothesis of innocence put forward is the notion of justifiable use of deadly force, and so I'm going to move to that. I think the facts testified to by the eyewitnesses who saw the defendant and the victim struggling together, upright, and at one point a pursuit involved, coupled with the inconsistencies and the expressions about the defendant's own attitude, more than create a substantial question for the jury in that regard. As to self-defense, whether or not the use of force, particularly in this case, the use of deadly force, is justified, the state has a burden to discuss here, and I'm going to refer the court to two cases in particular in this regard. And the first is Leisure versus State. That's Leasure, 105 Southern 3rd 5. That is the second DCA opinion from October of last year. Beginning on page 10, I believe, of the court's copy, under head note 3, or outline column 3, where they discuss the motion for judgment of acquittal as to self-defense. The court says this, and briefly the factual scenario is this. At trial, Leisure raised two separate arguments in support of her motion for judgment of acquittal. She asserted both of those that the defendant is asserting here, that the state failed to prove that she acted with the requisite intent, and also that the state failed to overcome her allegation of self-defense. When a defendant claims self-defense, the court said, she bears the initial burden of presenting a prima facie case of self-defense. Again, I'm going to assume for purposes of this argument that the court is satisfied the defense has done so, because if they haven't, school is out as to this already. I believe that it is a fair inference from the evidence in this case that the defendant started this, or at a very minimum that Trayvon Martin had as much right to defend himself as this defendant claims he did. But I'll get back to that notion in a minute. But where a defendant claims self-defense, the state has to rebut it, but the state has to do so in the following manner. State may present such evidence through rebuttal witnesses or by inference in its case in chief. Moving across to the next column, Leisure argued that the state failed to meet its burden because there were no eyewitnesses to contradict Leisure's testimony, and the medical evidence did not contradict her testimony. She argues that her inconsistent statements to the police were nothing more than the use of extremely poor judgment after she panicked. This is sounding exceedingly familiar. However, even when there are no other witnesses to the events besides the defendant, and in this case there weren't, even Mr. Good was long gone before the shot took place, a jury is not required to accept the defendant's testimony in support of her self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. Numerous inconsistent statements to the 911 operator and then to the detectives cast significant doubt on her assertions that she had a reasonable fear of death or great bodily harm. So let's talk about that. I will also go on to note that on page 11 of this court's opinion, under head note 4, there is a lengthy discussion of the standard as to the judgment of acquittal for the malice or the intent prong. And the law appears to be virtually identical, but I want to draw back to one thing. The bottom of that page, and moving on to the next page, circumstantial evidence standard does not require the jury to believe the defendant's version of the facts if the state produces conflicting testimony. Even when a defendant's theory of events is not clearly contradicted by direct evidence, a judgment of acquittal is not required. A common sense view of the circumstantial evidence might lead the jury to disbelieve the defendant's theory. They go on to cite some other cases of the same nature. And again, they cite Rasley, R-A-S-L-E-Y versus State, a first DCA case from 2004. And over in the second column on page 13, the middle paragraph, we reject Leisure's argument that this was merely a case of an impulsive overreaction to an attack or injury. The bottom of that page, a common sense view of Leisure's conflicting stories and the physical evidence that conflicted with her contentions, when considered together with the evidence of motive, could lead the jury to disbelieve Leisure's self-defense theory. I'm going to discuss why I think that, as opposed to the Jenkins case, this case is by far more, at least in a legal sense, and certainly as it relates to the nature of the arguments, far more close. The defendant was armed, fully loaded with hollow point bullets. The victim was not. The defendant outweighs Trayvon Martin by 40 or more pounds. In fact, he even said to the detectives he didn't even think Trayvon Martin was armed. The defendant's attitude about these assholes, these guys, calls him a suspect at every opportunity. He is operating contrary to his training. He's operating contrary to the direct suggestions of the police. According to the testimony of at least some of the witnesses, the defendant initiated that confrontation. There was running, there was a chase, there was an upright struggle. The defendant was seen atop the victim by a number of people. John Good saw the victim on top of the defendant. It doesn't mean the positions didn't get switched, that there wasn't a rolling struggle, but none of that justifies granting a judgment of acquittal. The defendant is the one with the MMA training. The defendant's injuries have at a minimum, by him, been significantly exaggerated. He was caught in several inconsistent statements, and I'm sure the court has noticed some, but let me put it this way. This defendant has been now exposed as having gone weeks after this incident in the company of his attorney on a nationally televised program in front of millions of people and told a flat-out lie, a big one, about whether he even knew about the nickname for the self-defense law in the state of Florida. He's demonstrated that he has no apparent compunction about doing something like that. I'm not sure why any jury should be presumed to have to take his word about anything else. And the only person who offers any evidence that the victim in this case, who ended up with the bullet in his heart, was the initial aggressor in any way, shape, form, or fashion, is the guy who went on Sean Hannity and lied. He certainly has the knowledge or the ability or the access to the materials in the background to construct a lie if, in fact, he saw fit. This is not some rube, some guy who's never been exposed to any of this. This is a person who's been studying this for years. The physical evidence is certainly inconsistent with his hypothesis of innocence. The position of the victim's body, the absence of DNA and fingerprints, the idea that somehow he was smothered and his nose was pinched with this horrific bleeding injury, not leaving a trace anywhere. There is, of course, the matter of who was screaming. At least two people have said that's Trayvon Martin. A third has said it sounded like a boy's voice. And the defendant, of course, in his recorded statement said that doesn't sound like me. Spin that how you want to. That's what he said. And then, of course, there's the common sense matter of the fact that the scream stopped when the gunshot got fired. The physical evidence of the wound itself and the hole both through the hoodie of Trayvon Martin and through his body, or into his body, it's been sort of suggested or argued, I think, several points throughout this case that it shows that the victim was leaning over the defendant when the shot got fired. And I guess he would have everybody believe that that is a possibility. That is equally consistent with the idea that Trayvon Martin was pulling away at the time the shot got fired, and that it wasn't some Arizona iced tea can dragging his hoodie out, but it was his body pulling it back. In either event, again, certainly open to a jury question as it relates to that. It is as consistent with the victim defending himself as it is with the defendant and his version. There is this supposedly horrific struggle during which the defendant claims at various points in time he sustained, 30 punches, 25 slams of his head to the concrete, all this screaming going on, this hand fighting and everything else, this straddling, and yet the murder wound is a single, perfectly straight, perfectly calibrated shot straight through the heart. The defendant is either the luckiest, most level-headed, cool marksman in the world, or something else is going on here. There is, John Good is relied upon in great part by the defense, and expectedly so. But even he says, I never actually saw or even heard any blows really land. Nobody heard 50 screams. I think there's a significant reason for the jury to question that even assuming that the defendant shot Trayvon Martin in some form of self-defense, that doesn't end the inquiry, and I think it's been oversimplified. Professor Carter alluded to this. No, the standard is whether it was reasonable that he feared imminent death or great bodily harm. Now, the defense has an argument that they have advanced that says that's it, but that's certainly not the only argument. It's not the law. It's not the instruction. The instruction is, was his action reasonable? And given what we now know about the defendant's version and how much credibility he has, the defendant's attitude and history and what he felt and thought, and the actual extent of the injuries, which again, the law, it is true that the law says you don't actually have to have injuries, but why exaggerate them? Why make them to something that they really aren't? So the question is whether he was reasonable in using that level of force, particularly if you believe the defense's theory that, well, he knew the police were going to be right there. So the one final inconsistency I'll point out as to whether or not this was self-defense is as it relates to the defendant's account to his best friend. When you think about it, the defendant swore that he was attempting to scoot or move or somehow get off the sidewalk at the time that he claims Trayvon Martin was above him with his knees to the defendant's armpits. And yet at that same time, according to the defendant, Trayvon Martin noticed the defendant's firearm and went for it. And the defendant, nonetheless, was able to grab it, pull it out, and as he demonstrated, fire it into his heart. I think that's a pretty big physical impossibility. I think everybody with common sense already realizes that. So the central question, Your Honor, is really which one of these individuals was most defending themselves. That is a question the jury should answer. I want to say something about the Jenkins case because Mr. O'Mara characterized that as, quote, one of the most instructive cases, and, quote, the facts are close. Here are the facts. Witnesses described Mr. Cerezo, that's the victim, as furious and a wild man. Mr. Jenkins testified that Mr. Cerezo was acting like a lunatic. Mr. Cerezo claimed that he was a gang member and that he would come back to the mobile home park with 20 guns and silencers and kill everybody. One of the witnesses testified he heard Mr. Cerezo yelling, "I'm going to kill you, you're a dead man." Another witness heard Mr. Cerezo threaten to burn down Mr. Jenkins' trailer. Mr. Cerezo claimed that he had a Glock with which he was going to cap Mr. Jenkins. Mr. Cerezo then clenched his fist and charged at Mr. Jenkins again. Those facts are not close. One of the final cases I cited to Your Honor is the case of Hoffman versus State, and I think I even saw this in the defendant's packet as well. The court cited the familiar, and this is the 5th District Court of Appeal, cited the familiar standard that I've already gone through several times. This is under Head Notes 1, 2, and 3. A motion for judgment of acquittal must be denied unless there is no legally sufficient evidence on which a trier of fact could base a verdict of guilt. In considering the motion, all facts introduced in evidence are considered admitted, and all inferences and conclusions must be drawn in favor of the state. Then we get to Head Note 4. A jury question is presented when the evidence is reasonably susceptible of two views, either that the defendant's action in shooting was justifiable self-defense, or that such action evinced a depraved mind without proper regard for the life of the victim. The evidence adduced at trial clearly allows for a difference of opinion between reasonable people as to whether the shooting was in self-defense, and therefore the court said that the motion denied. So I go back to the fact that one first has to consider whether or not the state has satisfied the standard at this stage of trial as it relates to the defendant's state of mind. We believe we have, both through direct and circumstantial evidence, even if the circumstantial evidence were considered alone. Secondly, assuming that, the only hypothesis of innocence advanced or suggested is that the defendant acted with justifiable use of deadly force. That is certainly open to question, as is everything pretty much that the defendant himself has said. So the state believes the motion should be denied. I will close by saying that even if the court felt compelled to grant at this stage a motion as to second-degree murder, there remains the necessarily lesser included offense of manslaughter, as to which there is no requirement of showing ill will or anything like that, and therefore the state believes that even if, and we're not saying you should because I think I've made the point, but even if, at a minimum, proceed forward on that charge. Thank you, Your Honor.
Yes, I just want to make sure that my rendition of the Jenkins facts are properly presented to the court. I did not suggest that Trayvon Martin said he was a gang member, did not say that he suggested he had a Glock, did not say he suggested he was going to cap Mr. Jenkins. And actually, these facts are more serious than what that victim did in the Jenkins case. Because in this case, we do have some undeniable evidence of what Mr. Trayvon Martin did. See, Cerveza, the victim in Jenkins, hit him one time and threatened a bunch. In this case, we know that the facts are so much more serious than that. Because in this case, they start out similar. Trayvon Martin sucker punched my client, and there's nothing to contradict that. And we have the injuries that suggest nothing else but what my client said right after the fact, before he knew there was an eyewitness to or not to it. But what Cerveza didn't do in the Jenkins case that Trayvon Martin did in this case was continue the attack, and continue the attack, and continue the attack. Because Jenkins didn't allow that to happen. Jenkins stabbed him to death with the second blow. My client waited an additional 40 seconds. So the suggestion that the Jenkins facts are inconsequential, actually that they're more severe than the Zimmerman facts, is just an ignorance of the fact, or at least its application to the law. Similarly, the state seems to ignore the reality of the Leisure case, because they suggested and actually spent a good part of their argument talking to you about the Leisure case and its applicability. Sometimes bad facts make bad law, but let's look at the Leisure case for a minute. You may remember this case. It wasn't that long ago. It's a case where Ms. Leisure stated to 911 three completely separate events of what happened. She said to the 911 operator, if I could have just a moment, because you know the case, well, just so that we're clear, in that case, Ms. Leisure came up with three completely different stories. He shot himself, I shot him in self-defense, you're going off accidentally. If those are the type of inconsistencies that the state wants you to focus on, please do. And if you want to fail to grant the judgment of acquittal in the Leisure case, you probably should. But the facts in the Zimmerman case are much, much different. Because what the state has sort of done is ignore the facts that they want to ignore. Because what they told you is here's their direct evidence. What he said on the non-emergency call. Not the way John Guy said it, not the way Bernie Deloranda says those expletives, but they want you to take from that phone call the beginnings of ill will, spite, and hatred. Because unfortunately, Mr. Manti decided not to address ill will, spite, and hatred virtually at all in his argument to you. In an offhand way at the end, he said, well, if you're going to get rid of second degree, at least don't get rid of manslaughter. But where is the state's case that even in the light most favorable to them, looking at all of the evidence, not just that which they wish to focus you on, but all of the evidence, how they get to ill will, spite, and hatred? That he made up stories? Well, you have an opportunity to review the evidence. You sat through here with all of it, just like we did, and see whether or not those stories were made up. Whether or not, as Serino stated, and as Singleton stated, they were insignificant changes. Matter of fact, they were changes or developments that they would expect the more time they questioned somebody. That's why John Good's half of a page statement went to a 4-page statement, went to an 8-page statement, went to a 50-page deposition. You know it as well as I do, and you know what? As well as the state does. That's why they can't come here and say to you, he said he shot him in self-defense, he said the gun went off by itself. There is none of that. Those inconsistencies are merely what happens when you tell a story 2 or 3 or 4 times to different officers after you've been through 2 traumatic events. Getting the hell beat out of you by Your Honor, getting beat up by somebody the way he did, and then the trauma of having to shoot somebody to defend your life. Now, we can minimize the trauma that George Zimmerman has gone through, but we really can't when we're going to compare what happened in his statements, because if you want to look at what is in the light most favorable to the state and say to them, you know what, I'm going to rule that one in your favor, as we've said many times in this room, you can't do it in a vacuum. You can't look at it and say, this little fact I'll put in your favor, goes on your side. This little fact I put in your favor. You have to look at the totality of the circumstances and see whether or not the direct evidence that they say they have convinces you. One piece of direct evidence that they've shown to you, and I'm presuming that they've shown you all of their direct evidence already, and that Mr. Manti just took an opportunity to present to you all of that direct evidence which supports ill will, hatred, spite. And they said, we have Nofke. We have my client dared to suggest that he was on drugs. It is not properly before this court as to the veracity of my client's understanding as to how Mr. Martin may have been acting. But you can certainly consider everything that you've heard with the way he said he was acting. So that's a second piece of direct evidence that my client thought he was on drugs. And then he said he wouldn't have done anything differently. He didn't do anything wrong. He contends that to the police officers in every statement he gave. He didn't do anything wrong. He contended that to Sean Hannity. I wouldn't have changed anything. Now, does that mean, maybe that's the callous indifference to human life and ill will. I shot him and I don't care. It's not what was said, it's not what was intended, and that's an absurd suggestion. That when he said, I didn't do anything wrong, I wouldn't change anything with what I did, that suggests that he, like any one of us, wouldn't have decided not to wake up that day, or get in the car that afternoon, or go to Target that night. That type of an absurdity suggestion by the state should not be considered as valid argument to you as to why this court should not grant a judgment of acquittal. And you have said, I would opine, and I know that I have said, whenever a tragedy happens, that it's God's plan. Every time I've lost a loved one, that past has either come through my lips or through my brain, that we have to think to something beyond ourselves to decide why something crazy, terrible, horrible happens. If you actually believe that that is evidence of ill will, spite, and hatred, if they're actually suggesting, because after all, if we're going to compound inference upon inference, they got to take their pick. Either he is a wonderfully creative and perfect murderer who can come up with the best of plans in a split second, but then 6 weeks later, or whatever he says something that is just from his heart, and now that's ill will and hatred. Give him credit one way or the other. Or just suggest that you know what he was, and you know what he is? It's just a human being. Yeah, he was going to school. He had decent grades, a book he may have read or not. The reality is he went through a traumatic time, and he's trying to deal with it just like the Martin family is trying to deal with it. They have more of a loss. My client carries his in life. They carry theirs through death. But the reality is you have to look at the direct evidence that the state presents to you to say, have they proven their case to the extent that they should get the benefit of the JOA standard? So, direct evidence, Rachel Gentile, get off. Yeah. If that's at all credible, if that was at all credible, the way it was presented by Mr. Crump, the way it was presented by her, and the way it was presented, if that's the only word that I'll use rather than created, after the inquiry with Miss Sabrina Fulton at the house and then with Mr. Bernie Delarianda at the house, so be it. Then they say that Mora and Sudaika suggest pursuit. You'll remember the testimony, I guess, better than mine, but Mora said nothing about pursuit, though she did think that she saw George Zimmerman on top. No pursuit. Sudaika never said anything about pursuit from my memory of the testimony, and I was here for that. What she said was she heard something down below. No suggestion of pursuit, nothing like that. And of course, what she thought she heard was the child who she saw later as the one screaming or yelling. And then we have Bahadur, we talked about that. There was no pursuit suggested by Bahadur. All she said was she saw something, maybe somebody went from left to right. And I realize at this stage the state gets the benefit of those inaccuracies, but they can't just make believe that if they're going to support that as direct evidence, that's all they've got. That's all they said. Now they talk about circumstantial evidence. The fact that he's with Neighborhood Watch, calls up Neighborhood Watch and says, I'm with Neighborhood Watch, and doesn't say that's Trayvon Martin, you know why? He never got the chance to. He got hit first. Because the evidence is uncontradicted and therefore cannot be denied. When my client's statements that are before this court uncontradicted to say exactly what happened, those have to be given weight by this court. And since it's now on the level of circumstantial evidence that the state is now trying to convince you, they did not address specifically the standard of what happens with circumstantial evidence, but I will remind the court that, in fact, it does have to exclude any reasonable hypothesis of innocence. And of course there's only one, as though it's minimal, as though it's minor. Well, the only hypothesis of innocence is self-defense. Of course it is. There wouldn't be any other one. There doesn't need to be any one. This isn't a quantification. It's a qualification analysis. He was acting in self-defense. Show me how you have proven that there is no reasonable hypothesis of innocence being equated to self-defense. And he was told not to follow circumstantial evidence, except they have no evidence to support that he did. Now, I don't want to just sentence for sentence go over what Mr. Manti said, but when we talk about circumstantial evidence, we have to do it with the filter of excluding the reasonable hypothesis. So now all of a sudden, George's decision, you heard the tape half a dozen times, some sinister decision, I guess is what the state wants you to believe, that George is on the phone. Where should I meet you? Should I have him meet you at the clubhouse? Yes. Or maybe in my car? Yes. And I guess it was at that precise moment in time that he became the mastermind murderer that the state wants you to believe he is. And I'm not saying this for effect. I'm saying this because if this is their circumstantial evidence that they want you to consider, it has to exclude a reasonable hypothesis of innocence. So they now want you to think it was precisely at that moment that Mr. Zimmerman became the mastermind murderer who said, you know what? I'm going hunting. I'm going after him. I'll call you when I'm done. There's no evidence to support that. No evidence to support that. Not in the tone of his voice. Not in, by the way, if in fact he was going hunting, probably would have had his gun out. Probably wouldn't have had the broken nose. Probably wouldn't have had his head bashed several times. So they just want to throw this inference out and say, well, look at that in a vacuum and say that that is a circumstantial evidence piece that you can say doesn't exclude or excludes every reasonable hypothesis of innocence. Even in a judgment of acquittal argument, Your Honor, though you look at the evidence in totality and say, do I look at it in the light most favorable to the state, you do not in that analysis ignore common sense. That's not the purpose of the judgment of acquittal standard. Judgment of acquittal standard is to say, if I take every little thing and look at it in the state's favor, do they win? Not do I have to bend over backwards, do I have to ignore common sense to let this case go to a jury. And quite honestly, if it was the standard as suggested by the state, there wouldn't be an appellate case granting a JOA ever. Because under their standard, I'm presuming some indication of some set of facts could support a jury deciding guilt. No, not in a circumstantial evidence case, and this is, if not 100%, as I suggest, it is at least 98% circumstantial evidence. The other evidence is, yes, he was there. Great. And yes, he shot him. There's no question about that. That's direct evidence. But as to the issues that count, was he justified in doing it? Is it self-defense? Where's the direct evidence that it wasn't? Ill will, spite, hatred. Where's the direct evidence that it was? There isn't any. Then we're on the circumstantial evidence standard, and we've talked about that now, maybe a touch too long. I'm glad that Mr. Manti, while mentioning the injuries, suggested as well that injuries are not necessary. You know that. We all know that. Witnesses may or may not know that. It is only Mr. Zimmerman's fear of great bodily injury that allows him to act in self-defense. And if, in fact, there is an evidence, a presentation that has come before this court to support that reasonable hypothesis of innocence, that George Zimmerman reasonably believed he had to act in self-defense, then the judgment of acquittal should be granted. The reason why is there is absolutely no evidence which could be taken in the light most favorable to the state that at the time he shot, there's been no evidence whatsoever to suggest that under the law that he was the initial aggressor. They want to say that, but they know they have absolutely no evidence to say that. They want to, and they will, at closing, I presume, should we get to that, but there's absolutely no evidence to support that. So if that's not true, and we also know even if it was true, screaming for help would have done away with that, but the real focus is at the time he got that gun and shot, was his fear of great bodily injury reasonable? I defer to Captain Carter again, and I defer to your common sense. Those injuries were not stopping. Every one of those individually could be great bodily injury. Did he survive the attack without great bodily injury? Yeah, I think he probably did. I wasn't kidding when I asked Dr. Rao, what about the next one? That wasn't just some sneaky little question to have. That's really the question of the case. It's not the question of what he survived. It's a question of it wasn't going to stop. Yeah, if Tim Smith had been 30 seconds, 45 seconds, a minute and a half earlier, it wouldn't have happened. But he didn't know that. All he knew was that Trayvon Martin wasn't stopping the attack after 40 seconds of George Zimmerman screaming. And in fact, if that is, the state has absolutely nothing to deny that reasonable hypothesis of innocence. And if it's true, then the case law says, even at JOA, it has to be granted. Now, the other part about common sense is I can't say to you, and therefore the state can't say to you, here's a possibility. We know we have this argument here, and he gets shot. We know we have that. Here's another one, not supported by any evidence whatsoever. Nothing to support that. But let's just say that George was holding on to his arm. With one hand, he had the shirt. And Trayvon was trying to pull back. He was, at that precise moment, which is the state's position, he was receding from the attack, pulling away. And George just decided not, Mrs. Zimmerman just decided not to let him go with one arm, and with the other arm decided, are you kidding? Is that actually the state's case that they want you to buy into and say that denies a reasonable hypothesis of innocence? That's what he must have done? Give me one shred of evidence to support that. It doesn't exist anywhere. What they're doing is grasping for straws in a case that none of the evidence supports ill will, hatred. None of it. And none of it contraindicates a reasonable hypothesis that George Zimmerman had to act in self-defense. Why did he exaggerate his injuries? Is that a reason not to grant judgment of acquittal? Because George said, I thought I got hit 50 times. Really? Is that the common sense that we're going to leave at our doorstep when we consider what we're going to look at with what he did go through? I don't know if it's 50. It looks like 12. Rao says it was, Dr. Rao says it was as little as 4, maybe as many as 12. Good Lord. Let's be realistic. We know who had the injuries. We know who didn't. It was a sad and tragic affair, but Trayvon Martin did, in fact, cause his own death, and this man should not face a jury any longer than he has already.
Thank you both very much for your arguments. I have reviewed all of the case law. I listened very closely to your arguments. The court finds that the state has presented sufficient evidence, both direct and circumstantial, to allow his charge to go to the jury. The motions for judgment of acquittal are denied. You have a witness that's ready? I want to ask the jury what they would like to do. They've been sitting back there, and if they would like to start to hear, then we'll go ahead and call your first witness since you have one. When the jury comes back in, the state needs to rest on the record. Okay, are we ready to bring the jury in? Pardon?
I think we formally have to do that in front of the jury, the exhibit, the 2 exhibits. That would just take a second, obviously. 193, I think it is.
Paper? Ready? Okay, let's go ahead and bring the jury in.
Jury present, Your Honor.
Please be seated. Ladies and gentlemen, I know you've been sitting back there a long time, but I wanted to assure you that we have been working diligently here in the courtroom while you have been sitting there, and we appreciate your patience. Mr. De La Rianda.
Your Honor, the state would introduce into evidence State Exhibit 213, which is a weather report. Judicial notice has been taken. And then also State Exhibit 193, which is a timeline of the pertinent phone calls and the gunshot and the Officer Smith arriving at RTL by car.
Okay, and based upon the court's prior rulings, they will be admitted into evidence.
The state will then announce that we will rest our case.
Okay, defense ready with, let me ask the jury. I know you've been sitting back there, and we do have a witness that is ready to go. I'm going to leave it up to you. Do you want to hear the witness, or do you want to go home for the evening?
No.
They want to go on for the, you want to continue on? Okay.
Couple minutes, Your Honor.
Yeah, call your first witness.
May I have a couple minutes outside the courtroom?
Yes.
Defense will call Zimmerman, Your Honor.
Would you raise your right hand, please? You solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do, so help me God.
I'll need a moment to get a recording audio. So this is yours. Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon, Mr. Mayor.
Tell us your name,
Gladys Zimmerman?
and I know that you would rather not state your address, correct?
Correct.
But tell me, you live in Seminole County
I live
or
in
in Central Florida?
Central Florida.
Thank you. And how long have you lived in Central Florida?
6 years.
And of course, you know George Zimmerman, correct?
Yes, sir.
And tell me how, or tell the jury how you know him.
He's my son.
And do you have other children?
Yes, sir.
Their names?
Robert John Zimmerman Jr., Grace Zimmerman.
And of course, you know why we're here. Your son is in second-degree murder charge right now, correct?
Yes, sir.
Okay. I want to talk to you or have you listen to a tape. I'm going to limit my questions to you today to just a couple regarding the tape. But premise that, have you listened to a tape that has the 911 phone call by Miss Laura with screams in the back of it?
Yes, sir.
Okay. If I might, Your Honor, I would like to play this. What I would like to do is let you listen to it one time through. I'm going to ask you if you know whose voice it is, or if you tell me if you want to listen to it a second time, or if not, okay?
Yes, sir.
As I begin that, I'm going to presume that you were around with George most of his life, correct, as he grew up as a child?
Yes, sir.
Had an opportunity to hear him in all different voices, laughing, screaming, yelling, crying?
Yes, sir.
Okay. Do you think that you have enough knowledge of his voice that you would be able to tell his voice if you were to hear it?
Yes, sir.
If I might, Your Honor.
Do you need police, fire, medical? Maybe both, I'm not sure. There's just someone screaming outside. Okay, what's the address that they're near? 1211 Twin Trees Lane. Twin Trees Lane? Is this in the Twin Lakes homes in Sanford? Yes. Okay, and is it a male or female? It sounds like a male. And you don't know why? I don't know why. I think they're yelling help, but I don't know. Just send someone quick, please. Okay. Does he look hurt to you? I can't see him. I don't want to go out there. I don't know what's going on. They're sending. So you think he's yelling help? Yes. What is your number?
Were you able to hear that voice
Yes, sir.
in the background?
Yes.
You heard, of course, a woman's voice in the foreground, correct?
Yes, sir.
Do you know whose voice that was screaming in the background?
Yes, sir.
And whose voice was that?
My son, George.
And are you certain of that?
Because he's my son.
At this time, no other questions of this witness, Your Honor.
Thank you very much. Cross?
Good afternoon, ma'am.
Good afternoon, Mr. De La Rionda.
Ms. Zimmerman, you have heard him yelling out and for help or crying, or have you heard him just laughing and screaming?
All the above. All.
Isn't it true you've never heard him yelling for or crying for help, yelling for help?
Not for help. Not in that distinction.
Thank you very much, ma'am.
If I may. You've never heard him screaming for his life before, have you?
Correct.
But regarding, I'll rephrase it, have you ever heard him screaming for his life before this call?
What I'm sure is that that's George's voice.
Okay. So,
The scream is I haven't heard him like that before, but the anguish that scream, that he's, the way that he's screaming, it describes to me anguish, fear, I would say terror.
and is that the anguish, fear, and terror without question of your son's voice?
Yes, sir.
May Mrs. Zimmerman be
Yes.
excused? I'm sorry. Were you finished with your answer?
Yes, yes, ma'am.
May Mrs. Zimmerman be excused?
Yes, for now.
That is subject to being recalled.
Okay.
Yes, we will maintain our discipline.
Okay, Mrs. Zimmerman, you're excused from the courtroom, but you may be recalled back. Okay, thank you. Call your next witness, please.
Jorge Meza, M-E-Z-A.
Raise your right hand, please. You solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God.
Help me God.
Thank you.
Afternoon. You may proceed.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
State your name, please,
My name is Jorge Mesa.
and your occupation.
I'm currently a deputy sheriff with Orange County Sheriff's Office, assigned to the courthouse division.
And how long have you been in that position?
I've been in that position since September 2007.
Consistent from that time through today?
Yes, sir.
And before 2007, what type of work did you do?
I was previously assigned to the Courthouse Services Division between May of 2000 until August 2003. Before that, I was in the Army. I served our nation for 26 years. I retired of the Army with the rank of a Command Sergeant Major, and I felt that it was my duty to serve my community.
And is that why you began service with the Orange County Sheriff's Office?
Yes, sir.
In effect, if you weren't on the witness stand and we were maybe a county over, you might be sitting there or standing in the back?
That is correct. That would be my duty.
That's the type of work that you do?
Yes, sir.
So I presume that you've sat through more trials than probably anybody else in the courtroom, or except for these two individuals, correct?
I have had my share.
Okay. We bring you here today, though, not in your capacity as a deputy, but you're here because you know George Zimmerman. Is that correct?
That is absolutely correct. I am here as an uncle to George Zimmerman, not as an sworn deputy of the Orange County Sheriff's Office.
And then how long have you known George Zimmerman?
I have known George Zimmerman since October the 5th, 1983, the day he was born.
Okay. Were you still back in the Army then, correct?
Yes, sir. I was stationed, at that time I was stationed in Puerto Rico, and with a temporary duty assignment in Atlanta, Georgia, when the news arrived that my sister was actually having labor pains, and I was in transit, and when I was checking into the hotel in Atlanta, Georgia, is when I got the news that my nephew has been born.
And I was going to ask the connection, but I think you just told us in your story, and that is that are you Gladys Zimmerman's brother?
Yes, I am.
And how many other siblings do you and she have?
She has her older son, Robert Jr., and then she has my niece, Christina.
And do you and she have any siblings? You and Gladys have any siblings?
My brother, Luis Miguel.
You are here today because I want to ask you if you've ever had an opportunity to listen to a 911 call that had certain voices in the foreground and then a screaming voice in the background.
Yes, sir, I did.
What I'd like you to do, if you would, is to tell the jury the first time and the circumstances that you had heard that call.
The exact date, I don't remember. It was sometime in March of 2012. I am sitting in my computer at home, involved, to be exact, I cannot recall, but I was in the computer, and all of a sudden, the TV in my house is located right behind. If I would, I show you, this is my desk, and right behind me is my television. When I'm actually working the computer, my wife is watching the news. All what I did hear was the scream. A scream that it came immediately. Not only I just heard the scream, I felt the scream, like my nephew screaming for his life. It was a moment that I actually lived with me every moment that I heard the portion of that. Because it was, the feeling of saying, oh, I heard Georgie. It was George screaming for his life. And I took to my wife and I says, what are you watching? And she says, I'm watching the news. I says, but what is the news about? She says, they're playing the record of the 9/11 call pertaining to the person screaming. I said, that is George. And I stood up and looked at the TV. And I just didn't see anything else, but it was just the recording playing at that time.
This wasn't a situation where somebody played it for you to ask you to identify the voice?
No, sir, it was not.
Was this just coincidental that it happened to come on TV?
No, sir, it was not even coincidental. Like I said, I was just working on the computer doing exactly, I cannot really tell you what I was doing, but I was in the computer. and that voice just came and hit me. It hit me in a way that I heard that, but more than heard that, I felt it inside of my heart. That says, that is George.
Did you even know that the TV was addressing your nephew's case?
No, I did not.
Did your wife tell you anything about the fact that it was on TV?
Matter of fact, she did not.
Then, and I think you mentioned it, what was the very first thing that brought your attention to the TV?
His voice. His voice. The reason why I recognize his voice is very simple. I have had George play with my sons, my own sons. It is unique way that you recognize your family members when they laugh or when they cry. And this was the moment that I recognized George as screaming for help. It was George screaming for help.
Have a moment, Your Honor. Thank you, Your Honor, for the questions.
Thank you, Cross.
Good afternoon, sir.
Good afternoon, sir.
Just so the record is clear, you're not here speaking as a deputy sheriff, correct?
No, sir, I am not.
Okay. So the jury should just disregard when you were bringing about your qualifications, which are awesome. That has nothing to do with...
Let me object, Your Honor, to a suggestion that the jury should disregard. I'm sorry.
What's the legal basis for your objection?
Improper questioning of the witness. I'd rather do it at the bench than to speak.
Let me do it this way. The court is going to instruct you at the end of all the evidence of what the instructions are in the law that you're to follow. So I'm going to hope that you will follow those instructions. I'm going to instruct you to follow those instructions. I'm going to sustain the objection.
You'll have to rephrase it. You're not here testifying as a deputy sheriff of Orange County Sheriff's
No, sir, I'm
correct?
not.
You're here testifying as George Zimmerman's uncle.
I am here as a witness of what I heard.
But you're here on behalf of George Zimmerman because he is your nephew. In other words, that's the relationship with you. Not because you're a deputy sheriff is what I'm trying to get.
Yes, sir.
Okay. And you were aware prior to hearing this on TV, the recording, you were aware that your son was involved in this shooting. You didn't know the facts, but you were aware of it, correct?
You mean my nephew?
I apologize. I said your son. I apologize. Your nephew, George Zimmerman.
Yes, sir, I did.
Okay, so you were aware of that.
Yes, sir.
And what you're telling this jury is that you didn't know any of the specific facts, correct?
No.
And that was on purpose because you're a deputy sheriff in Orange County.
I am a sworn deputy law enforcement officer. If I actually wouldn't know any facts, details, information provided to me, it will be against my ethics and professionalism to get involved.
Right. So you on purpose kept out of it, is what I'm trying
Yes.
to get at. Is
Yes,
that
I did.
accurate?
Up to
That was
this
on
moment.
purpose?
Yes, sir.
Thank you. But you knew that he was involved in the shooting, you just didn't know the specifics.
I didn't know the specifics.
Okay. And you're saying as you heard this on TV, it was the news, I believe, correct?
That is correct.
And I think you stated your wife was watching the news.
That is correct, sir.
And then when you saw it, after hearing it, you saw it, there was something on about George Zimmerman case, right, on the news itself when you saw it, correct? There was like
Before I saw what I saw, I heard the scream.
Right,
And that's what I get up and says, that is George. What are you watching?
right. And then when you saw the TV screen,
George-
it did have the name George Zimmerman on there, correct?
That is correct.
Okay. And I believe you stated you had heard him before playing with your son, correct?
That is
Him being
correct.
George Zimmerman, I apologize.
I understand, yes, sir.
Okay. But you never had heard George Zimmerman crying out for help before, had you?
Not the way I did that day.
Okay, thank you very much, sir.
Any redirect?
Briefly on some of the issues addressed. Obviously, you're not here as a deputy. Do you take your oath to tell the truth seriously?
I took my oath on 31 May 2000. I am the class of the millennium, and up to this day, I stand for my oath to the law of the state of Florida.
So, you would not color your testimony to favor your nephew, would you?
My ethics and professionalism is stated with the 26 years that I stayed in the Army, achieving the rank of Command Sergeant Major, and I will never compromise myself to do that either for my son, my daughter, or my nephew.
So much so that you decided to maintain that oath to just keep away from the facts of the case, correct?
That is correct.
These questions.
I'm sorry, what?
Leading,
Okay,
I'll acknowledge it was leading, it's just that it had just been testified to, but I'll rephrase it.
thank you.
Why was it that you decided not to find out more about the facts of what your nephew was going through?
As a law enforcement officer, you are sworn to actually tell the truth. I don't know when this moment was going to arrive that I was going to be sitting here, and I wanted to be able to look at everyone, members of the jurors, and tell them the truth.
Thank you, nothing further.
so if I understand you correctly, Mr. Mesa, you're saying that you anticipated that you would be hearing this recording and you were going to have to come in court and testify about it?
No, sir,
That's
you
why-
misunderstood what I said.
Okay, I want to make sure.
What I said is, as a law enforcement officer, the moment that I found out of this situation that arose, I disconnected myself totally from it.
You disconnected yourself totally from the case, not wanting to, you didn't want to find
I
anything about
didn't
it?
want to, no, sir, I didn't.
Thank you very much, sir.
Thank you. May Mr. Meza be excused?
Yes, sir, I'll maintain subpoena over him, but for
Okay.
today.
Thank you, sir. You're excused from the courtroom, but you're subject to being recalled.
Thank you, Your Honor.
Thank you. Call your next witness, please.
Can we approach him a little
Yes,
bit?
you may. Gentlemen, this is a good breaking time for everybody. So I'm going to recess until Monday morning at 9 a.m. Over the weekend, you're not to discuss the case amongst yourselves nor with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have all of your assurances that you will abide by these instructions? Okay, and with that, if you'll put your notepads face down, have a good weekend. We'll see you Monday at 9 a.m. And counsel, when their jury is out, can you approach for just 1 moment? Okay, there's nothing else that council needs the court's attention for. We're going to recess until Monday morning at 9 a.m. Have a good weekend. Court is in recess.